Talking today about deeds of release or deeds of mutual release and indemnity. Where these documents are really fundamental is when there's a dispute between the parties and the parties want to resolve the dispute and have got an agreement to resolve it, but want to document that agreement in the form of a deed, and it has to be a deed for those purposes. In order to dispose of the proceedings and agree between the parties on a confidential basis what that agreement is. Some really common terms of a deed can be confidentiality about the agreement. That's paramount usually to one party, almost a deal breaker. Disparagement clauses to make sure that no one after this, that the dispute's over and done with. There's no more agitation, and there's no talk of poor talk against one another after the deed is signed, so that then there's no further agitation or issues about any disparagement or defamation after that date. Other clauses include releases of claims and defining what a claim is, making sure that there's no comebacks after a deed is signed. It's really fundamental to make sure that these clauses have great definitions to make sure they're all encompassing. What you want is a no comeback situation where this is it, it's full and final settlement of all claims they may or may have anticipated as a result of the proceedings or the dispute, and basically what you want to do is tie this up nice and neat with a piece of string and make sure that there's no room for later on someone's coming back and saying, oh, well, that wasn't agreed as part of the settlement, and so therefore I can go again and have a double dip of the claim. So just spelling out all these things, and they're more. A lot of these documents we find are fairly simply drafted, but they don't anticipate all of the potential of consequences. And unless you've gone through that and realise what can happen afterwards if they're not tied up properly, I don't think people fully know how important every single line and word in a deed of release is. And after doing hundreds and hundreds and hundreds of these documents, we're very experienced at making sure that once a matter is resolved, that's it, and no more proceedings and no more actions and no more complaints or agitation after the event, and making sure that everybody walks away and hopefully never deals with each other again, which is what everyone wants after a piece of litigation, especially the longer it's fought or the more money that's put into it. So it's really vital to make sure that these documents are drafted very, very carefully to make sure that doesn't happen, which is what it's all about. A lot of litigants tend to get to the end and just want it over and done with and out the door. But if there's no better time to make sure that's done before any monies are handed over, and make sure that all the I's are dotted and T's are crossed, to make sure that there's that's full and final. Then the proceedings are dismissed after certain things happen, and then releases come into effect to make sure that there's no comebacks. Hope that helped.